Namaskara to everyone. Jai Sri Ram. Suswagatam. So my name is Chandrasekhar, and on behalf of the Shri Kamakshi Aarsha Samskriti Trust, I warmly welcome you all to today's event on protection of temples. About the activities of the trust. The trust was established about a year and a half ago, the blessings of the Kanchi Shankaracharya. Our activities encompass areas such as Go Samrakshanam, Veda Samrakshanam, supporting poor families, including temple archakas who need financial assistance for education, be it regular or Vedic education, medical treatment, or marriages of the daughters, and a range of other activities aligned with the preservation and propagation of Sanatana Dharma. Today's session is an initiative born of our keen interest in the protection of our temples, which are the cornerstone of our civilization. And unfortunately, our temples have been under attack in various ways, right, in the decades since independence. So this response to this initiative of ours has been very heartening. We have had, I think we have more than 108 registration, and I'm saying 108 because it's a holy number for all of us. So we have, and of these, we have at least 12 law students and 10 practicing lawyers. And this community is a very critical cog in the wheel of this movement to protect and free our temples. We also have several engineers, some teachers, and passionate Sanatanis who can all contribute their might to this movement. So we are not looking at today's session as a as a one-off event after which we forget about it. Right? Instead, it's the beginning of something long-term and concrete in terms of how we can all contribute. I extend a hearty welcome to our esteemed speakers for today, Shri Ravilochanan Iyengar and Shri Kiran Bettadapur. Both of them are very inspiring personalities, very active in the protection of temples. I will begin with a brief introduction to the trust and its activity. Please. Hello, somebody speaking?
Sundarji, please mute yourself.
Okay. So I extend a hearty welcome to our esteemed speakers. Both of them are very inspiring personalities, very active in this mission of protection of our temples. It's our honor to have you both in our midst today, and we look forward to a very engaging and insightful session. We also look forward to your valuable guidance as in terms of potential next steps for lawyers and law students in this group, and also for everybody else in today's group, in terms of how we can contribute. So the format of the session today will be, first Ravilochan ji will share his perspectives. Following that, Kiran ji will share his insights. Followed, I think this should take around 1 hour, and then we will have Q&A. So we have a good number of pre-submitted questions, so they will be given priority. And then if we have time, we can have additional questions using the chat, YouTube live chat. So request is to use the chat only for new questions or to report any technical issues that we have with the video stream. Right? Quick introduction to Ravilochan ji. So he is a founding trustee of Indic Collective Trust, which has made a mark in advocacy of Indic civilizational issues using constitutional process to arrive at solutions to problems that undermine Indic communities. So he is a finance professional who is interested in economics and history. He's also a student of Indic orthopraxy, philosophy, and demographics. So welcome, Raviji, and the floor is yours.
Thank you, and namaste to everyone. So the topic that we had taken up is actually something which is capable of being discussed upon for hours together. It is a vast topic. I tried to keep it as brief as possible, and make as much of the time that has been given to me. The first thing that I would like to tell everyone here is that when we talk about protection of temples, most people that I have met in my past 5 to 7 years of what I will call as advocacy and public life is that they wonder why we are worried about protection of temples in a place like India, where Hindus are a majority and the temples are generally filled with devotees. At least the large temples are. especially in a state like Tamil Nadu or Karnataka or Andhra Pradesh, we see how the large temples are teeming with devotees, festivals are happening in a very grand manner. But the very purpose of a temple has been forgotten by us, unfortunately. So let me start from there. A temple is a place where the deity has been consecrated with the idea that the deity will be treated like the emperor of the universe. I mean, Triloka Chakravarti or Chakravartini, if it is a Devi temple. The primary purpose of a temple is not darshana. Please understand that. The primary purpose of a temple is to serve the deity. The deity shall be served by the sevaks of the deity in the temple. And people who have faith in the deity are supposed to help in ensuring that the seva continues. And irrespective of the fact that whether we visit the temple or not, provided that we have faith in the deity, we even pray to the deity mentally, and the deity is served well in the temple, the phala will come to you. Darshana is secondary. Primary purpose is serving the deity. In any temple, when you go, keep in mind that it is the deity who is pradhana. Today, I am sitting in Tirumala, and a primary example of how things are, completely upturned today. Here, in the name of supposedly ensuring that devotees have easy access or whatever they want to call it, Venkateshwara is not given due time for rest. His pujas are not happening exactly on the time as it is supposed to be. The Rajabhoga will be, brought to an earlier time on Friday to ensure that the crowd is manageable or whatever. So the point is, the way the temples are managed today is that the devotees who are seen by the government administrators as what I would call as customers of the temple are served to the extent where they can get maximum money out of the wealthy customers. It is like how a bank or any other institution tries to serve high net worth individuals in a better manner, the large customers in a better manner. I mean, temples are managed in a way as though it is a commercial institution. So even in temples which are supposedly in a better shape, like Tirumala, the very purpose of temple has been completely lost, in my opinion. So let us keep this in mind first. The temple is there to serve the deity. The reason for Tirumala temple to exist is to serve Venkateshwara. Devotees and everyone else has to come after that. Keeping this in mind, let us look at what happens in the temples which are being managed by government across India. Fortunately or unfortunately, most of the old and large temples are found only in the southern India, in Dakshina Bharata, due to the fact that we had a far lesser number of years of Islamic rule here compared to northern India, which suffered much under them. So we have been able to save our temples better, thanks to the Vijayanagara Empire, which existed here, or the Gajapatis in Odisha. So due to this situation, we see how a vast number of millennia-old temples are found only in the southern part of the country. And hence, the so-called Hindu religious and charitable endowment departments, HRC departments, or any other word that is used to describe them, Devaswam department, Muzrai department, Devasthan department, whatever, they are managing a huge number of temples in southern India. I think outside southern India, Rajasthan perhaps has the maximum number of temples under government control. Of course, Gujarat, Uttarakhand, Uttar Pradesh, Madhya Pradesh, everywhere the government control exists to a certain extent in the large temples anyway. So none of these, let me categorize these temples into three levels. One, what I will call as the very large temples, and by large I don't mean the size, but rather income, because that is how the government is looking at our temples. They are classifying them based on the income that they are generating, right? Large temples are those which generate 10 lakhs or 1 crore of income, or perhaps even more per annum. And the lowest grade temples in Tamil Nadu are those where the annual income is estimated to be less than 10,000 rupees. Now you have to ask why the government even exists in a temple where the annual income is less than 10,000. We'll come back to it later. But in these large temples, the primary function of the government has been to ensure that more money is realized from the devotees. The properties of the temples are never put into good use. Rent is never realized properly, be it in Tamil Nadu, Andhra Pradesh, or anywhere else. It has been a fact that most of the temple lands are misappropriated or illegally occupied by the big wigs who have power in today's political arena. So that is also one reason why some of the lower grade temples have been taken over. They don't have income as per the government, but they would have 40-50 acres of land which are being encroached upon by these local political guys. And naturally, they don't pay anything to the temple. The temple goes into disuse. We'll come to it a bit later. But so, coming to these large temples, the primary aim is to earn a lot of money from the temple. And what they use this money for? In a place like Tirupati, TTD has about 18,000 employees. Anyone who has been working in a large organization will know that there is certainly no requirement for this place to have 18,000 employees. What happens is that whichever party comes to power, they will put some of their people here as employees. It is used as a quid pro quo job giving institution, and they are paid hefty salaries. Vast majority of the funds of TTD are used only to pay salaries to these 18,000 people. And a very small amount of money is only spent on dharma karma. And if you take the case of other temples, the same thing continues. And one place where all these temples are used as cash cows is when they indulge in what I call as contract giri, in the sense that civil contracts are given supposedly for development of temple or the temple areas or whatever, and money is expended on it. Everyone knows how government contracts involve kickbacks, and it is exactly what we are hearing in all these temples as well. So the normal thing that we hear is 20 to 30%, or in some cases even 40% is demanded as kickbacks. And many of these expenses don't even have anything to do with temple. Let us take the case of Rajasthan. Srinathji temple is the largest and the richest temple in Rajasthan, or perhaps in the entire northern India, for that matter, which is under government control. And one thing you will notice there is that the Srinathji temple built a hostel, a girls' hostel, in the land which belongs to the temple. And then the board transferred the hostel to government. So essentially, the government wanted a hostel to be built there. They used temple funds to get it done. So what has Srinathji temple done for propagation of Vallabhacharya Vaishnava Pantha, to which this temple belongs? Almost nothing. But temple funds from Srinathji temple have been utilized for laying roads there, for underground drainage system. I mean, all sorts of things which the government is supposed to do. Money has been utilized from the temple. Shirdi Sai temple was, I will say, forced to donate about 500 crores. They call it as a loan, but it is a loan without interest and without a repayment period. So that is essentially a loot. 500 crores were transferred from Shirdi Sai temple to the Maharashtra government for development projects. This kind of nonsense will not happen with any other place of worship of other religions, right? So open loot happens in our temples, in the large temples. Next come the middle income temples, where the temple is self-sufficient, but they can actually do some good to the local community as well. Doesn't happen. Once again, the temple property money is never realized. In fact, that is never realized in any of the temples for that matter properly. We will take the case of only Tamil Nadu. A simple back of hand calculation done by us would show that given the amount of land that is owned by the Tamil Nadu temples, HRC department is supposed to realize at least 8 to 10,000 crore rupees. I mean, 6,000 crores, which is what we estimated back in 2014. Today, it will be more than 10,000 crores per year from these temple lands, and they can be used to manage all our temples in a very beautiful manner. But the actual realization is less than 200 crores. A very pathetic state of affairs. 2% of the realizable value. So this is how the temple properties have been, I will say, gutted. In many cases, the lands have been illegally transferred to others as well. And we are talking about 10,000 crores only based on the lands which were in the name of temples by 1980s or 1990s. If we go a bit further, we will see that more lands have been alienated before that. So the actual amount would be much more than this. So the first place where temple protection is something where Hindus have to really interfere, in my opinion, is to ensure that temples are first treated as temples, not as commercial establishments. We have failed very miserably. This has to be taken up. Secondly, temple properties have to be managed in a proper manner. The government entered these temples stating that we will manage the properties better. It is not the duty of an endowment department to interfere in the religious matters of the temple or the rituals. Today, the practice is that if a annual festival has to happen in, let's say, Meenakshi Mandir, the Meenakshi Temple of Madurai, the EO is the person who takes the most prime position there, as though he conducts everything there. I mean, he has no business. The only thing that he's supposed to do is to allocate funds for the festival. The acharyas of the temple, the priests are supposed to give the requirements for the festival to be conducted, and he is supposed to facilitate it. He is merely an administrator of properties, and his work there, the EO's work there, is to ensure that income is realized properly and the money is managed properly, which is certainly not done by this department. So what is the use of them being in the temple? Merely to milk our temples, nothing else. Middle income temples which exist throughout the country. By middle income, I will refer to temples like your what do you call it? The Uppiliappan temple of Kumbakonam, Tirunageshwaram temple in Kumbakonam. Prime examples where the temples can actually support the entire local community there. But the money is not put to such use. No dharma prachara happens. And the worst part is, in all these temples, there used to be hereditary sevaks. And by hereditary sevaks, I am not referring to only the archakas, the musicians, garland makers, even those who did washing of clothes in the temples. Many of these things were hereditary. And there is a reason why these people were appointed in the past. They would belong to the same sampradaya as the temple. They would have a great identity with the temple's practices. They would be having a rich tradition of serving in the temple. And so their attachment to the temple will be much more than a normal employee. So imagine a person who is a musician in a temple, who plays nadaswaram or tabal or mridanga, and if he comes from a family which has been serving the temple for 500 years, the amount of dedication that he will have towards the temple will be extraordinary compared to someone who has been appointed there for, let us say, 2 years, and he is then asked to transfer to some other place. And in most of these cases, appointments are not even being made now. Salary is not even paid properly to the archakas. Many Archakas are getting salary of 1,000 rupees, 1,500 rupees. Let us not even talk about these poor other employees. There are cases where uh, before the government interfered, a temple used to have 14 sevaks. And currently there will be only 2 sevaks, one Archaka and one Parichaka. No one else. If it is possible for a temple to be managed without the priest, the government will do that as well. Unfortunately for them, unfortunately for us, they have not figured out a way by which they can get it done till now. Which is why perhaps at least the pujari exists in the temple now. So this is the second line of problem. The third line is a huge number of temples are in disrepair. Tamil Nadu government itself says in the court that there are more than 10,000 temples where no worship happens. No puja is done. The reason they claim is that there is no income to these temples. But the government has taken over these temples only because these temples have a good amount of properties. If they realize income from these properties at the market rate, the temples can be managed very beautifully. That is not happening. And if you look at it, most of these temples are in remote villages. They have gone into disrepair, which means the local population there do not have a place for spiritual solace. And then comes the soul vulture offering spiritual solace. They will build, as we know, their own place of worship. They will try for conversions. So in a way, when a government takes over these village temples, they are enabling conversion of Hindus to other religions, because the Hindus don't have a place for worship due to the government interference. This is the state of affairs. So what can be done about it? I always hold that there are 2 ways to handle the situation. One is what I will call as public pressure. The second is legal advocacy. Indic Collective is primarily into legal advocacy, where we identify the problems, we gather what I will call as information through RTAs, through old records, archival records. We compare it with what is happening now and what used to happen earlier, or rather the standard practice as it should be compared to the deteriorated state of affairs now. We take up these matters, we agitate about it in the court, we call for to be thrown out of the temples. So this is legal advocacy. We also indulge in what we will call as some amount of PR exercise to take these matters to the public. As I said, most of the Hindus are surprised to hear that government loots the temples in such blatant manner, and the government is actually destroying our temples. They also, by they I mean the government. The governments also try to utilize various what I will call as fissures in the society in their favor. Divide and rule is something which perhaps the British started, but our current brown babus are very much capable of following the same, and they are clear descendants of the British rulers in that aspect. Take the example of Tamil Nadu. If you talk about temples, the first thing that any so-called Dravidian ideology guy will tell you is that Brahmins have, the Brahmins are the people who control these temples. They want the temple to be within their control. All sorts of nonsensical logic. And they will want, the temples with Agama traditions to be filled with Archakas who are not from the Agama background. Now, the interesting point is, out of more than 40,000 temples under government control in Tamil Nadu, hardly 8,000 temples have Brahmin Archakas. By a vast majority of temples are having pujaris from various other communities. There are a lot of Brahmins in Tamil Nadu for whom the Kuladeva is a deity of a temple where the pujari will not be a Brahmana. So the the very argument that only Brahmins are pujaris is nonsense. The fact is that every temple has its own sampradaya, and according to the sampradaya, the archakas are appointed. And the most interesting thing that which is never spoken about is 98% of the Brahmins can never become priest in any of the temples. The priestly community among the Brahmin caste is a very small micro minority. They are mostly endogamous communities as well. A normal Smarta Vaishnava Brahmana can never become a pujari. So it is not even a question of caste. It is a question of specific small micro communities, and the same across all castes. There are temples where certain families of a particular caste will be the hereditary archakas. The caste would be not a Brahman caste, but a Kshatriya or a Vaishya or OBC. There are temples where SCs and STs are priests. So all these arguments that are made supposedly against the traditional temple management is bunkum and absolute nonsense. They are being propped up as what we call as strawmen only to somehow hoodwink the public and ensure that government control continues in these temples, where they can loot the temples in a very blatant manner, perhaps to the extent which even the British might not have thought about. Even when the British directly managed our temples in the 19th century for about 5 to 6 centuries, they ensured that the temples were actually functioning. Only the excess amount was taken away by them. Here, the so-called independent India's governments have ensured that most of the temples, or perhaps not most, but a good chunk of temples are not even functioning properly. They don't even have puja for a single time in a day, and many temples are closed for that matter. It's a statement given by the government itself, Tamil Nadu government, and the High Court of Madras. So this being the state of affairs, what we are doing currently is primarily legal advocacy, as I said. On the other side, which I would actually want people to think about, is to put pressure on the government, form local communities who are interested in the temple day, and ensure that whenever any government babu or a politician comes, you talk about the temple, how the temple has to be restored properly, because most of these what I call as the village temples or low income temples have been left in disuse. They have gone into disrepair. It is in a very horrible state of affairs in many of these villages. Let them be restored first, and then the temple has to be given back to the community, to the sampradaya, the people who follow the sampradaya of the temple. Let them manage it. Only place where the government can interfere is if there is a financial mismanagement. Just as in any private limited company, if there is a mismanagement, the NCLT comes in, sets the things right, and then gives it back to the shareholders. The same thing should happen at max. Otherwise, the government has no business in handling my temples. They are only destroying everything. They are not doing anything positive to my temples. That is one thing. So unless an actual ground level pressure group, governments are not going to care about this. Because for every government is a cash cow. We have seen how in Karnataka, BJP government stated that they would free the Hindu temples, then they went back on their promise. Because even if some politicians at the higher level are interested in supposedly doing the good deed, most of our politicians are not good, and they would create their own pressure groups to ensure that the cash cows remain as cash cows. So unless we wake up and create pressure groups, this is not going to happen. On the legal side, we have to approach the court and show how all these things are unconstitutional. That has been started by us. There is Dayananda Saraswati case in the Supreme Court where the HRCE legislations have been challenged. It was started by Shri Dayananda Saraswati ji, then currently being managed by the Temple Worshippers Society and Ramesh ji, who is also our president of Indic Collective Trust. And then there are multiple cases in the Madras High Court, in Kerala High Court, or for that matter, even the Supreme Court. We are planning some cases in Karnataka now, as well as in Andhra Pradesh, where two things are done. One is where we are challenging the presence of government in many of the large temples initially, because that is where the government is currently earning a lot of money. So take it away from them, the department can collapse, which is good thing. And the other thing, we are challenging all sorts of nonsensical changes that the government wants to do in the rituals and the traditions of the temple, be it in the appointment of the sevaks, or in trying to change the rituals of a temple. The government does everything except proper financial management of the temple, or rather the intelligent mismanagement of the temple as well. So to put it very briefly, temples at present are in a very bad shape of affairs only because they are under government control, the babus. In fact, someone might ask me, what about a situation where the private trustees of the temple start indulging in financial impropriety? It can happen. I'm not denying it. But the point is, when such things happen, you can easily approach the courts about it. You can approach the commissioner of trust, let's say in a place like Maharashtra. Things are set right easily in such cases. And when a private trustee is handling these temple money, they generally do not have the guts to, let us say, loot 50 to 60% of the temple income. The max amount of corruption that will happen will be much smaller. Whereas when the babus handle the temples, there is no external audit in our temples when the temples are managed by babus. Internal audit in Tamil Nadu alone, millions of audit objections are remaining unsolved for decades. If it happens in any private institution, heads will roll. Nothing is happening here. Right? So government control only enables a large scale of corruption, which is why we say that government has to definitely get out of temple. Anyway, the secular government has no business in my religious place of worship. I would try to end with this. I think I already reached 30 minutes of my time, most probably. It is 4:07. So any further things, I'll answer in the Q&A session. Thanks to everyone here.
Thank you, Ravilochanji. Thank you for your wonderful speech, and also I think you are in Tirumala. So I really thank you for taking time to join this and um, um, talk to our audience here. Yeah. So next we have a very another interesting talk by Kiran Bettadapur. So he's a quick introduction. So he's a practicing advocate. He's a managing partner of Prudential Law Chambers, and he's also like a patent lawyer and a qualified company secretary. So he has a very strong background qualification. He's an alumnus of IIT Kharagpur and IIC Bangalore. So though he's an engineer, like he is now an advocate, practicing advocate, right? And he's also a keen interest with a lot of entrepreneurship. He has co-founded several ventures, and he also is equally interested in legal activism and constitutional reforms. And his book on Gita and the Art of Selling, right, so was nominated for Crossword Book of the Year award. Okay. So so I welcome Kiranji for this wonderful evening and talk. Thank you for your time. It's all yours, Kiranji.
Hari Om Tat Sat to all of you. I have a presentation, so I was wondering if I could share it.
Definitely, definitely. I'm going to stop sharing.
Is it sharing? No.
No.
Yeah.
There is a icon in the bottom.
Yes, I know. Share screen. But anyway, if it fails, I'll just go ahead with the presentation. I understand this is a heterogeneous audience. So what I've also looked at the questions that some of the audience members had shared earlier. I will try to make sure that my talk is mutually exclusive, the questions, and also some of the points that Shri Rajiv Lochanji covered. And then, of course, I would like to have an interactive session with the audience. I want to start off. There is a temple. It's a Shiva temple in Aihole. Aihole is in northern part of Karnataka. It's a beautiful 7th century AD temple. The architectural style is that of the Western Chalukyas. The Chalukya style itself, architectural style, if you look at it, of temple construction, it looks very ordinary from a distance. But the beauty of the style is, if you go close to the temple and look at the pillars and the walls, they are extremely intricate. Even the gopurams, so much so that it is believed that this is a Vesara style, and it is believed that it was a precursor for the intricate Hoysala style. Now, this Shiva temple, 7th century Shiva temple, was attacked by the Bahmani kings, the Bahmani Sultanate, Adil Shah, and it was obviously destroyed, desecrated, and the general of the army made it his dwelling. Now, this temple was taken over by the ASI. The irony of it is, ASI referred to it as the Lord Khan temple. You know, the temple is destroyed, looted, and we go in and name the temple after the person who attacked it and destroyed it. The second point that I want to talk about is in a recent talk show, Ajit Hanumakkanavar, he's a very well-known talk show Kannada host. On a program, there was talk about the Waqf amendment bill. And the reason why I'm bringing in Waqf is to draw a parallel with our own Endowments Act. One of the speakers said the land on which the Vidhana Sauda is located is Waqf land. Now, it put me into a tizzy. I spent substantial amount of time researching old records, and I found that the land on which the Sauda is located was actually part of the civil and military station during the British rule. Bangalore had two parts during the Srirangpatna forces post Tipu Sultan were based in Srirangpatna, but the military, the army, the British army felt Bangalore had a more salubrious weather climate. So they wanted, the entire army was switched to Bangalore. And that's what is referred to as cantonment today, Bangalore cantonment. Those of you who visited Bangalore by train from Chennai will know that before you get to Bangalore Central, the main railway station, you get to Bangalore cantonment. Now, not only is there absolutely no record of the Vidhan Sauda land ever being a Waqf land, I even looked up the list of awqafs. Awqaf is the plural for Waqf. And the Waqf board announces this list, it does not appear there. There is a Aga Ali Askar, who was a Persian. He was a horse trainer who came to Bangalore in the 19th century. And he had a trust, he had his property because the British engaged him to construct several of their colonial bungalows in the civil and military station part of Bangalore. Bangalore itself was at that time divided into Pete, which is pretty much the city market and majestic area, and then the cantonment area. Now, so not only is there any record of that land having been endowed to the Ali Asgar Trust. Like, for instance, if you were to look it up, you will see that where you have the Windsor Manor, a 5-star hotel, that land is apparently it belongs to the Ali Asgar Trust, which is not the case for Vidhana Saudha. Not only that, if at all there was some, if at all prior to the land being declared as part of civil and military station Bangalore, if at all the land belonged to a religious institution, it would be a temple, because there is a temple adjacent to Vidhana Saudha called Arali Muneshwara Devasthana. Now, the point that I'm trying to make is historically, there is no substance in the claim. Cartographically, there is no substance to the claim. And the only conclusion that one can draw is that probably the speaker who made this tall claim had a Goebbelsian approach in mind. You just continue to speak a lie 1,000 times, and eventually it ends up becoming the truth. Third example that I want to give is that of this temple called Adikesava Perumal Temple in Tiruvattar in Kanyakumari district. I could have given any number of examples from Karnataka, but this, for a reason, I chose this temple in Tamil Nadu. It was part of the Travancore princely empire, princely state, pre-independence. And post-reorganization of states, we all know Kanyakumari went to Tamil Nadu, and rest of Travancore was aligned as part of reorganization with Kerala. Now, this was also one of the state deities. We all know about the Ananta Padmanabha Swami Devalaya. Now, this temple also had substantial movables, immovables, as you would imagine, endowed, gifted, offerings made by the royal family. In 1992, it was found that many of the jewels were missing. They had been stolen. And as you would imagine, the criminal justice system got into the act, and it was believed that the Archakas were responsible for it, and some of them were even convicted sometime in 2017, 18, 19. Now, this is a common modus operandi. Now, for me, if government has taken over a temple, Archakas, the custody of the valuables are with government. The procedures and the processes that are followed are with government. It is impossible, in my view, for Archakas to collude and perpetrate a crime of this magnitude. It clearly is a failure of the state government and the endowments department, to be specific. But nonetheless, 1992 to 2017, a good 25 years, no bureaucrats held accountable. And even to this day, there are cases ongoing in the Honorable Madras High Court about the loot that has taken place in this temple, Adikesava Perumal Temple. And from what I understand, even recently, as recently as 2021-22, apparently a kilo of gold was missing. And the Madras High Court has repeatedly asked the government to furnish a list of movable items that are there, that belong to the temple, and the government has failed to do so despite repeated reminders. So 3 points. Now, if you look at it, if you look at the way if you look at whatever has happened in the Sri Adikesava Perumal temple, and then also the Vidhan Sauda, the example that I gave, and the Lord Khan temple, the Shiva temple, Aihole temple that I gave, it is in stark contrast to what goes on under the Waqf Act. Now, Waqf itself is defined, and obviously there is an amendment that is on the anvil, but till the amendment gets enacted, we have to go by the existing enactment. And I'm going to read. Waqf means the permanent dedication. This is section 3, subsection R, small r. Means the permanent dedication by any person of any movable or immovable property for any purpose recognized by the Muslim law as pious, religious, or charitable. Now, I don't have to be a Muslim. As a Hindu, I can submit to the Waqf board that the land where the Vidhan Sauda is standing today is Waqf land, and give some historical background, come up with some documentation, some references to justify it. And it becomes Waqf. There is a procedure, obviously, but that procedure is so slipshod and so porous that it is very easy for any ordinary individual to circumvent it. Now, once it is declared as Waqf, under the due process of law, alienation of Waqf property, and that is under section 51, subsection 1, capital A. Any sale, gift, exchange, mortgage, or transfer of Waqf property shall be void ab initio, which means once a property becomes Waqf, you cannot alienate it at all ad infinitum. What you can do is you can develop the property. One, you can lease the property. Basically, the options that are available on Waqf land are only twofold, either lease or develop. Develop again for leasing purposes, have a building on the land and lease out the area, the premises. In contrast, the Endowments Act of Karnataka, section 62, alienation of immovable property. Now, I'm not going to read the whole provision, but I'm only going to read the relevant extract from the section. Subsection 1, section 62, subsection 1. Alienation of immovable property, there is a condition precedent, but the following phrase is important. It can be sanctioned by the state government as being necessary or beneficial to the institution. There is no board, no devotees, nobody who come into the picture. If it is a endowments institution, Hindu temple, for instance, the government can sanction alienation. And the procedure is in the rules, Rule 28. The procedure is as follows, interestingly. Every proposal, and the procedure permits sale, gift, mortgage, lease, exchange of immovable property. And if a property, immovable property, were to be alienated fraudulently, there is no equivalent provision for the transfer being deemed to be void ab initio. Interestingly, every proposal shall be published by notification. The notification may be published in the notice board of the institution, jurisdictional Grama Panchayat office, and it goes on, Tahsildar's office. The state government may consider objections. Interesting. Firstly, you notify it. And how do you notify it? On the notice board. Secondly, what do you do after that? Let's say if devotees were to object to it, the state government is not under an obligation to consider those objections or suggestions. And it may hold an inquiry if necessary. It is not mandatory. The state government decides whether it is necessary to hold the inquiry and pass an appropriate order, keeping in view the institution, the interest of the institution. So the judge, jury, and executioner, when it comes to alienation of immovable property belonging to temples is concerned, it is the government. So on one hand, if you see, there is this stringent provisions for a certain religion, and there is a complete dilution of the provisions for the Hindu Dharma. Now, in my view, I mean, we know the kind of scams that this country has witnessed over the last 70, 75 years, and some have estimated this to be $20+ trillion equivalent since 1947, if all the scams that were there. And obviously, this list only had the scams, the central government scams. It does not include the state government scams. I would dread to think of the number if the state government scams were also to be included in this list. It is my considered opinion that the temple scams, loot, be it of movable property or immovable property, dwarfs all these scams put together, and the figure of $20 trillion is humongous. Despite that, I say that, you know, if you were to look at take any temple, the lands have been alienated left, right, and center. They've been encroached upon. Even temple lands have also been declared as Waqf property. We have had those cases in Karnataka. The point that I'm trying to make is, who do we blame for this? I go to the extent of saying we Hindus, we are to blame ourselves. Are we so lethargic? Are we so dumb, incompetent? That, I mean, after all, how many temples are we talking about? We are talking about across the country, 4 lakh temples, 40,000 temples in Tamil Nadu, 35,000 temples in Karnataka. And if you keep adding them all, about 4 lakh temples and 100 crore Hindus. Why is it that we have this lackadaisical attitude towards our own temples and protecting our temples? Because they are not only do they represent our cultural heritage, our ethos, they are pretty much our identity itself. As part of my presentation, I also had some of the points that Shri Ravilochanan already talked about, so I'm going to skip about it. To me, a temple, it represents history. There is a history to it, heritage, there is art, architecture, and it is also the hub of the local economy, as well as engineering excellence. There's also engineering excellence in it. So all of this, if you were to look at it, I'll say we need to necessarily put pressure. Ravilochanan already talked about putting pressure on government. Temple autonomy, to me, is the only way forward. The Chidambaram temple judgment is there. He did talk about it, and the Puja Swami Dayanand Saraswati ji's petition is also there in the Supreme Court. I know all about it. And in the Chidambaram temple judgment, clearly the Supreme Court has held that if at all government were to take over a temple because of mismanagement, it has to rectify the management, the governance, implement good governance systems in there, and get the hell out. And 2 years is the time frame that the learned lordships talked about. To me, the temple autonomy is about 12 T's, and it is not T as in TEA or TE, but T-wise T's. And these are, when we look at these old 1,000 years, 1,500, 2,000-year-old temples, we cannot forget aesthetic beauty, architectural purity, structural integrity. I can give you any number of examples where there are holes being drilled into 1,000-year-old magnificent pillars, as part of the structure. The quality of material that is used, if let's say a repair or development were to be carried out. spiritual sanctity of the temple, ritualistic propriety, administrative probity, socio-cultural activity, religious liberty, constitutional equality, which is grossly, gravely missing. And I did touch upon it. Devotional dignity, as a devotee, my dignity is also at stake when government is controlling it and not allowing me to perform the sevas that would normally be carried out of the deity. And also when my rights as a devotee are trampled upon. But the most important T in all of this, all of these beauty, integrity, structural dignity, all that, we can never forget the rights of the deity. The deity, once prana pratishtapana is done, carried out, it is divinity residing there. We've given it a particular shape, particular form. It's a image. For me as a devotee, it is absolutely vital that be protected. So in a nutshell, if I were to summarize, we know all that the endowments department and the government does. But the unknowns, there are so many of these, the kickbacks that go on, the government expenses that are paid for by the temple, embezzle, misappropriation that goes on, theft, pilferage. It is so common. Unfortunately for us, we are spread too thin. There are very few activists in this space. So if you were to ask me, what is the solution for all this? Way back in 1959, there was a C.P. Ramaswamy Iyer commission that was constituted. That commission came up, the commission was constituted and it held office for 2 years, almost, maybe a little over 2 years, collected a lot of inputs from all stakeholders. And based on that, it came out with the C.P. Ramaswamy Iyer commission recommendations to the government. And it did recommend that the central government needs to have an umbrella legislation that has been gathering dust. We here in Bangalore, I and some of the professors in IASC, Professor Kanchi Gopinath, some of us got together. We studied the systems that are in place for well-managed private temples like the Dharmasthala temple, other temples, Satya Sai, then smaller temples, Ragigudda, Anjaneyas, small, mid-tier and large temples. Large temple being the Dharmasthala temple, Manjunatheshwara temple. And based on that, we came up with a list of recommendations for implementation. And we were surprised to see that almost 80 to 90% of what we came up as good practices, good governance practices, were already talked about in the C.P. Ramaswamy Iyer recommendations. The C.P. Ramaswamy Iyer recommendations are 60, 70 years old, and obviously there will be a little bit of tweaking that one would have to do. But the essence of the report is valid, is relevant even today. So the four foundational principles on which the report was itself based: dharmic authority to be formed, separate adjudication fora to be instituted, not the district courts and the high courts, etc., registration of all institutions that are there, and regulation. Government, as a parallel, it's like holding a pigeon in your hand. You squeeze it too tight, you're bound to injure the pigeon. You hold it too loosely, the pigeon is going to fly away. Government has a right, has a sovereign right to regulate. But unfortunately in India, and unfortunately for we Hindus, government is managing, it's administering these institutions, and they have no business whatsoever. If we call ourselves secular, government has no business to be administering temples, and we all know what the reason is. Shri Ravilochanan ji did talk about it, and he brought it out eloquently. It is plain and simple. It is loot-mar that is going on. From an activism perspective, there are 5 the way people can get involved in this movement. One is media activism. Be it mainstream media, social media, influencing journalists, getting them to host shows, talking about all the mismanagement that is going on in endowment temples, to RTI activism. Unfortunately, RTI activism is considered a part and parcel of legal activism. That is not true. It is impossible for an advocate. I can go fight a battle royal in a court of law, but for me to also gather inputs for it, it is extremely difficult. And I can give you the example of Dattapita in Chikmagalur, where there is both Muslims and Hindus are claiming right to worship at that shrine. Representations submitted by Hindus had about 300 plus signatures, and I'm told the representation from the other side had 18,000 plus signatures. Now, unless and until it becomes a mass movement, it becomes extremely, and it has to be RTI activism driven. Academic activism is something that we are extremely weak in. We need the more people who get into look at the historical background of temples, the better it is. Legal activism, I already talked about. And perhaps the most important part of it, political activism. Ravilochanan did talk about pressure. I'm also going to include protests under it. How many of us have this practice of writing, sending out representations to the local MLA, the local corporator, the local MP, the Prime Minister's office, the Chief Minister's office, tweeting them, tagging them? I can count people who do this on my fingers, perhaps. So these are the areas wherein we do need a mass movement. 4 lakh temples, 100 crore Hindus. We have 2,500 Hindus per temple. We just need 5 of them per temple to just focus on each temple and then give the inputs, do all this, give the inputs that lawyers like us, like me, need to fight it out in courts. Thank you very much. Jai Shri Ram. Questions?
Thank you so much.
Last point, though, I just want to talk about is we all know yada yada hi dharmasya. You know, we presumably, we Hindus, we expect divinity to reincarnate and get us out. But I would go to the extent of saying each one of us needs to invoke the divinity in us and then and take up this battle against government.
Thank you so much, Kiranji, for that excellent and very inspiring and passionate speech. Before we head on to Q&A, one request I had is, because we have some law students and lawyers in this group, if they are interested in taking this up, learning more about the legislations that apply to this topic, right? What would you, I think this question is for both you and Raviji in terms of how they can, take the next step.
Anybody who wants to intern with me, they are welcome. But then that has to be in Bangalore.
Raviji?
As a trust, I am not a lawyer. As a trustee, I am not a lawyer, neither is T.R. Rameshji a lawyer. But yes, people can intern with us because we do work on legal cases. We take their help. We will, associate them with particular cases, ask them to deal with our lawyers in Madras or for that matter in Kerala or anywhere else. If it is in Chennai, it will be very preferable. If the person is not based out of Chennai, we can consider it based on how much can be done from a remote location.
Sure, thanks for that. I think we will use this forum, this beginning to, take such initiatives forward. Maybe we can also engage further on potentially arranging some workshops for interested candidates to, help educate them about the legislative aspect of the temple administration. So we'll proceed to the Q&A. Sundar, can you share the slide? So we had a good number of questions that were submitted by the group prior to this event. So we will prioritize those Now, some of these questions may have already been addressed as part of the talk. Okay, so what I'll do is we will, I'll just alternate between Raviji and Kiranji. And if you want to, cede to the other, that please do so. And if you think it has already been covered adequately in the speech, we can skip and move forward. Okay? So the first one is, there are so many heritage temples not maintained well and neglected. So what is the main reason for that? So Raviji, I'll let you answer this.
As I already said, these heritage temples are mostly in villages. Their primary source of income is land rent. And naturally, the government babus are not keen on realizing rent from there. There is a mafia there which, misappropriates these lands, misuses these lands. So, in the name of lack of income or revenue, they are not maintaining these heritage temples properly. Ideally, I would say that the archaeology department of the ASI has to actually take over the maintenance and restoration of any temple which is more than 250, 300 years old at the bare minimum. But it is not happening in India. One of the very many unfortunate things here.
Okay. Go to the next question. So this is about legal activism. So I think Kiranji, you already mentioned that the number of people who are involved in this area, we spread too thin, right? And I think that answers this question as to why there aren't more legal actions against the occupation of temples.
It has actually improved in the past 1 decade. If you go a decade earlier, it was even worse. Only now people are waking up, and I hope it increases further.
Just to add to this, the challenge when it comes to lands and basically immovable property is revenue records. They get concocted, they get falsified. It's very easy to do it if somebody has power. I mean, even without power, all that you need to do is if you have custody of those documents, you can falsify those documents very easily. And that's the real challenge. If you were to take all the lands that have been encroached upon and alienated fraudulently, my gut feel is it would run into maybe lakhs of hectares, millions of hectares. And each temple, for you to look at, the unfortunate thing is government is the custodian of all land records, and they will have access to those records for the last, let's say, 100, 150 years, since 1860 when the first survey was carried out. But we don't. And for us to get it through the RTI process is a excruciating, time-consuming process. You file an application, they don't respond. You go in on a first appeal, they don't respond. You go in on a second appeal, and the second appeal takes 2 to 3 years to get disposed of. It calls for a lot of patience and a lot of feet on the ground, a lot of people working on it and diligently focusing on it.
Thank you. The next question is about those who wish to file PILs for protection of temples, right? And assume that they are complete newbie to this, right? So, what would the process entail, and what is the rough approximate cost involved in such activism? Kiran, you want to take that?
Sure. Very difficult to say what the total cost will be, for the simple reason that it depends on the reliefs that are being sought. And many times, and also the complexity of the matter itself. If it's an extremely complex matter involving, constitutional interpretation and things like that, not just statutory or procedural aspects, it can go on. And it also depends on how aggressively government is going to contest it. If government wants to adopt a very militant approach towards it, they can go in on an appeal and it can cost millions of rupees. Now, as a thumb rule, in our firm, admission, arguments, the initial work on it, the analysis of the matter on merits, all that which calls for senior counsel's involvement, we do it pro bono. It's just that the junior advocates who go in there, file the petition, take care of compliance, make sure that it gets listed, they are the ones that we always insist that they be paid. And so a rough estimate, it can be anywhere from 25,000 to, let's say, a couple of lakhs as a thumb rule.
Thank you. And I think the next question is related to this.
Yeah.
Can the cost of filing PIL and other legal costs be crowdfunded, or are there any restrictions to this?
No, sure, it can be crowdfunded.
Okay,
In fact, if there are 5 people, all 5 can be added as petitioners, for instance, in a writ petition or a PIL. There is no bar to that.
Kiranji, the question that they're asking is a bit different than 5 or 6 people coming together. It's like starting an online campaign where money can be collected for this purpose. Unfortunately, that is something which is frowned upon by several justices across high courts, as you know. At least in Madras High Court, if it is brought to the knowledge of the lordships that money has been collected publicly for filing a bill, they happily dismiss the bill. Crowdsourcing, as you said, 7 to 10 people coming together and doing together, that is fair enough. But I don't have a way by which I can go to the public on a fundraising campaign stating that I want to file a bill on, let's say, Tiruvatara temple, for that matter. Then that is frowned upon.
Even if crowdfunding were to be done, it could presumably be routed through a trust. Trust can raise, and which is very similar to what the state of affairs is in Karnataka. Generally, even when government relinquishes control over a temple, they would expect you not to raise funds in the name of the deity. So long as you are not raising funds for a specific cause, crowdfunding should be okay. It obviously depends on the objects of the trust. So if you have it and there are 10 objects and one of the objects is ensuring that temples are freed, or temple autonomy is one of the objects that you're going to work towards, I don't see an impediment in Karnataka, at least.
Thank you. The next question also is related to, I think, the funding strong legal cells to fight our case. Is there anything else you would like to add to this, Raviji? Or
no, I think this has been already covered.
Okay. Let's go to the next one. So if someone wants to protect or restore a temple, let's say my native temple or village temple, and we need legal help, whom can we approach?
Generally in Karnataka, I recommend that people form a society, basically engage with the local people, and also make sure that they are part of the society. Having said that, the large donations that are there, I would always insist that those donations be routed into a trust, and there be an arm's length between distance that is maintained between the trust, which holds substantial amount of resources, financial resources, and the society, which is more for broad basing the initiative, the temple management and administration movement. The reason being, the moment the funds of the society touches, let's say, a threshold of, let's say, 1 crore, you come under the radar of the government. I know it from personal experience. I'm essentially advising a society here. And the mistake, I told them to distance the big ticket collections from the society. And unfortunately, they didn't do it. And they raised crores. there was just 2 receipts of 1,000 rupees and the other of 500 rupees, wherein the receipt, because the donor said, I want to donate this money for this purpose. And when the receipt was made out, it was made out in the name of the deity. And guess what? A criminal complaint was filed against them. Misappropriation was alleged. What have you? So these are the challenges that are there. So please keep large amounts of money. Ideally, do not declare it as a public trust. It is even better if you can form it as a private trust. It needs a little bit of thought to be devoted. Because you need to have clarity. If it is a private trust, you need to have clarity on who the beneficiaries are. The beneficiaries need to be determinate. Whereas in a public trust, it is indeterminate. So, but it can be done. And that's what I would advise.
Thank you. Raviji, you want to add something to that from maybe a Tamil Nadu context?
No, it is the same case here as well. As he stated, you have to be a bit careful, and the steps that Kiranji mentioned are exactly what we're supposed to do. The one thing in Tamil Nadu that is generally done by us is where, if it is a very small village and we are taking care of a village temple, we don't do it in the name of any existing trust or society, but what we do is here, we ask the villagers to form a committee among themselves, and they are asked to give a representation to the HRC guys here. And when the village people form a committee and give a representation, and it is also endorsed by the panchayat leader there, then the government doesn't interfere in it after that. Once again, it is simply politicking, nothing else. Then the committee raises funds, they do things on their own. It is done in the name of the village people themselves. Then you will not be in any soup. I mean, apart from the methods that Kiranji mentioned, there is one more method that can be utilized. At least in Tamil Nadu, we are doing it. I believe even in Kerala, the same thing is being done by a couple of people who are in contact with us. Otherwise, everything else that he stated, I completely concur with.
Thank you. The next set of questions is about freeing temples from government control. So we can probably take all of this together. So the first one is, if there is a single key to free all temples in one go, or would different solutions apply to different temples? And of course, we have state-specific legislation, so I'm assuming the answer is no. And then assuming the temples are handed off to us or to the Hindu community, how would the handoff work? Would we need to form separate trusts for each temple? And again, a common counter argument is, potential misuse of temple funds by the private trust or committee. I think that was already addressed by Raviji, because, much larger scale of corruption is already happening in government control, right? So I think a quick reply from each of you, and then we can move on to the next one. Kiranji, your thoughts on these questions?
In my view, I hate to sound like a pessimist, but it is impossible to do one shot. It would be too optimistic for any one of us to hope for an overarching legislation at the center. It has been politicized, and honestly, nobody wants to set Hindu temples free for the simple reason that it is a cash cow. The best way would be to chip away at it and focus on the C category temples to begin with. Unfortunately, even in C category temples, there is a defined procedure process that is there in the rules that are there. Regulatory mechanisms are in place. They've been notified. Unfortunately, even there, ex officio, there will be government officials who would sit on the committee. Now, the moment you have a government official ex officio represented on a committee of devotees, a management committee, the whole purpose of freeing temples is lost. So to that extent, I feel, but honestly, till we look for monolithic mega solution, one-shot solution. Instead of going in for that, maybe we need to work on C category temples, because in Karnataka they are willing to let go control over C category temples. Only thing is, the caveat is they will have their officials sitting on the committee. So the moment they're sitting on the committee, then they have their own stooges, their own sidekicks coming in. The committee itself gets infiltrated by politicians. The quid pro quo that was being talked about earlier, all that is bound to happen. So even, in the current scenario, if you were to look at it, it's extremely difficult to get government out of temples 100%. But something is better than nothing, and you've got to work towards 100% autonomy in the long run.
Raviji, anything you'd like to add to this?
Nothing. Kiranji hit the nail very clearly. So,
Okay, before moving forward, a quick note. So we are, I think, 5 minutes from the closing scheduled closing time. We have a few questions to go. So I'm hoping, would it be all right if we went on for 10 more minutes or so?
Sure, I'm okay with
yeah,
it.
sure.
Okay. The next question is something about the Places of Worship Act 1991, which prevents reclamation of temples other than Ram Mandir. And I think the questioner heard that somebody, I think Vikram Sampat, tell that the law only applies to temples that are not older than 100 years. And is this true? Any grain of truth to this?
As far as I know, no such section exists here. Kiranji may correct me if I'm wrong.
No, I'm also of the same opinion, but having said that, I've honestly not studied the Places of Worship Act in such great detail as to give a answer one way or the other as to what the statutory provision is all about. But regardless, I mean, if there is an enactment, nothing stops us from having the enactment repealed. It is not an impediment. Unfortunately, we look at this, it's a churning the ocean kind of an approach. Instead of getting the Places of Worship Act repealed or amended, which is a huge thing, I think we need to look at smaller milestones, achieving smaller, having smaller goals and looking to achieve them, realistic goals, instead of looking for this huge, because we know in our country, there are all sorts of people, there are all sorts of inimical forces, if I may say so, that are at work. And it would be extremely difficult to take up such daunting tasks. But I think at some point in time, the key to it lies in, it's more political than anything else. We need to get our representatives who are pro Hindu autonomy, Hindu temple autonomy elected. Unfortunately, it's the most recent election has not panned out, presumably as well as any one of us would have hoped. I'm sure you all know what I'm talking about. It's extremely difficult to get a legislation passed at the center, let alone state governments.
True. Next category is about legal possibilities, right? So would it be possible to give temples, at least the large ones, the right to determine who can set up stalls in and around temple premises? If yes, is this incumbent upon having temples freed from government control?
In the Karnataka enactment, it does talk about temple premises. In fact, even the employees, temple employees and servants being Hindus, but it gets flouted frequently. And the problem is there are people who use Hindu names, to bid for these premises, enter into leases, subleases. It's a tough challenge, honestly speaking. But so long, in fact, instead of focusing on who the temple premises gets leased out to, or how you monetize those premises. I would go to the extent of saying, so long as you realize market rates, that itself will go a long way. Unfortunately, we are not able to do that in the first place. So, this is a tough question to answer, honestly. It's not easy because the problem is such, and it is so distributed. Each temple, the local committee, we've had instances wherein the telephone at the residence of the deputy commissioner was being paid out of temple funds. Temple funds, 100 crores in Karnataka in a particular temple, had been put into a fixed deposit with a nationalized bank at 2.5% per annum, when the prevailing fixed deposit interest rate was at 7%. Now, so you can imagine the challenge that you have. The problem is much, much larger. It runs much deeper than any one of us can even imagine.
Raviji, what is the scenario in Tamil Nadu with the HRC, right? Do temples have the right to determine this?
See, the problem here is, as Kiranji stated, there is, at least on paper, there is a statement which says that only Hindus can be allowed inside the temple premises, all that stuff. But when the government doesn't control, rules are fluted as usual. They float rules every way. Here also, the rules are fluted. And the other problem is, I don't see the government really doing this on their own, unless we manage to take the control of temples from the government's hands, because they do not have any incentive as of now to do this. We are divided, and it always boils down to money at the end of the day. And when the other side throws money for these things, it will definitely continue. And the other problem that I face generally is that it is not merely the temple premises, what we call as the car street or the Mada street around the temple, the immediate adjacent land. When that place is occupied by, shops which might even be selling beef, for that matter. It happens here and there in Kerala, in a couple of places in Tamil Nadu. Currently, there is nothing which stops these things from happening, unfortunately. I would prefer that the local community actually rises up to the occasion and demand that, just as pork cannot be sold or liquor cannot be sold near a mosque, similar a sensible thing be done for Hindu temples as well. But once again, it can happen only if the community exerts its pressure, or else it is not going to happen.
Right. I think one request is maybe we can be a little brief in your responses for the remaining questions, so we can try and cover maximum. So even if the temple, I think the freedom of temples is a long-term movement, but even without that, what can be done to have the governance as per the respective agama or parampara instead of some EO?
EOs, even by legislation, are not meant to actually interfere in the religious matters, and they are doing it in an illegal manner only. The problem is it is widespread, and not just in everything else. So, as I said, the legal things are there, but no one is implementing it, and you will have to go to the court for every occasion. The current problem is that. So, if there are 40,000 temples in Tamil Nadu, let's say they are being floated in 12,000 temples, you will have to identify the problems and then approach the court for each of these 12,000 temples. Not an easy job. A better chance is to I always prefer a case where Hindus can form groups and create pressure on the government. That is a far better resolution than going to the court and fighting for a decade or so. Legal activism has to be a second resort. Primary resort has to be unity among the Hindus and collective action.
True.
That can resolve most of things in a faster manner.
True. The next question is related to the.
So I just want to touch upon this question. Interestingly, it is very difficult for the Hindu community to be unified. I'll give you the example of Melkote temple. The dispute there was whether the namam should be the Vadagalai namam or the Tengalai namam. Divided the Hindu community, fighting it out in courts. What do you expect? Anyway, the court eventually said for some days of the week, it will be, Tengalai. Some days of the week, it would be Vadagalai. Even that was not acceptable. So courts are seized with the matter.
That's sad. Okay, the next one is about I think revenue collected by HRC or whatever body that is administering the court. So I think this is probably partly to do with auditing. I think Raviji already mentioned that external audit is not happening. So what influence can we bring to bear on these bodies like HRC to streamline the finances and audits?
In Tamil Nadu, we have already taken legal action on this issue. A case has been filed. M.R. Venkateshji represents us in the High Court here. Court has issued a notice as well, and they have come down very harshly on the HRC department for this, what we call as maladministration. I hope that this gets resolved, through a legal action, perhaps in a year or two at max, given how our courts function.
And I think from what I know, the Archakas are paid very poorly, right? So is there any chance of that improving?
I would put it in two ways. First, I'll talk about Tamil Nadu and then about Kerala and Karnataka. In TN, one person from Mannarkoil in southern Tamil Nadu, Sri Swami, he actually got a judgment where the HRC is supposed to revise the salaries in a proper manner. Unfortunately, they are delaying the implementation of it. I believe a contempt petition is due in this matter, and the petitioner there is also thinking of that now. So we'll see what can be done, because a step has already been taken, and thankfully it is not completely zero either, because they have indeed revised salaries in some of the temples, but it has not been done for all the temples. There lies the problem. So it is a work in process, you can see. In Kerala, thankfully in southern Kerala, be it Kerala is actually divided into 5 Devaswam boards. The temples under Travancore Devaswam Board, Cochin Devaswam Board, Kudalmanikam Devaswam Board, and Guruvayur Devaswam Board, they have a far better system of salaries and other emoluments. They are paid in line with the state government employees, which is a good thing. But Malabar Devaswam Board, which takes care of the northern Kerala temples, there everything is very similar to the Tamil Nadu HRC. So that has to be corrected there. Thankfully, the Kerala High Court had seized of the matter even in the 1990s itself, and they passed some orders regarding this matter. Since then, the payment has improved, but it is not to the extent of the other Devaswam boards. Currently, the Malabar Devaswam Board temple trustees, some of the prominent temples trustees are coming together on this issue to once again approach the court, and we are supporting them on this matter. Karnataka, Kiranji can add more on it, but one thing I would like to point out is my primary problem in Karnataka is something different. The government claims that they are giving 4,000 rupees per month to these C category or D category temples, or temples which very less income. But the point that is never talked about is that in Karnataka, most of the temple lands have been taken away under various land ceiling legislations, and this 4,000 that is being paid is supposedly a compensation for these lands. without considering how much lands have been taken away from each individual temple. So it is not even a grant by the government. It is something of a liability for them. But the problem exists in Karnataka as well. Kiranji can add more on.
Sure. What Rajiv ji is referring to is the Trustee allowance. Inam lands were resumed by the government, and the compensation for those lands is in the form of Trustee. Incidentally, is a Persian term. We in Karnataka, because of Tipu Sultan and Hyder Ali's rule, a lot of Persian terms and Arabic terms have entered the mainstream. But the Archaka issue, the income of, you will be surprised in Karnataka, there is a large section of Archakas that are against government relinquishing control over temples. Reason being, most of them are well-to-do Archakas who have been deputed to A-category temples. And they are a powerful lobby. While the smaller Archakas in smaller temples also are worried that even though this is just 2,000, 3,000, 4,000 a month, they are worried that if government were to relinquish its control over the temple, they're going to lose even that. The other part of the problem in Karnataka is the endowments department has reclaimed, has sought refund of some of these Trustee allowances that have been paid to Archakas. It's a the malignancy is set in, it's so deep rooted that each one will be a separate case that will have to be fought in courts if local activism were to fail. That's the problem that we have currently faced with in Karnataka, and I'm sure it is true for other parts of the country as well.
Yeah, thank you. Next question is about the Nataraja temple in Chidambaram. So recently HRC, I think, interfered in the matters of the temple, and the Supreme Court already ruled in favor of the Podu Dikshitars, right? So cannot the HRC be tried for contempt of court? Raviji, your answer.
See, currently what the HRC is attempting to do is to supposedly identify mismanagement in the temple and use it to somehow enter the temple management temporarily using the Supreme Court judgment on Chidambaram matter. But even then, they're actually not finding any instance of proper mismanagement. It is merely strawman arguments, and the Dikshitars themselves are contesting all these claims being made. They have approached the court already, the High Court. So yes, the legal process has already started. As of now, the government cannot take over the temple management, and I expect it to remain so in the near future as well.
Yeah, thank you. Next question is about.
I'll just add a quick soundbite to it. It's like Rakta Bija. The problem keeps growing and growing and growing. So it has to be a grassroots.
Thank you. Yeah, I think there was a question about these acts, HRC or the Karnataka Muzarai Act. Can we only, do we have to wait for a Hindu-friendly legislature to come in power to scrap these, or is there any other way, purely, say, judicial, to get them scrapped?
See, the primary and easiest way is to actually get it done through legislation. In fact, the central government can bring the central legislation on this issue, overriding all state legislations as well. Kiranji already pointed out, but there is no political will, which is where we are forced to go to the court. This is a secondary option, and I would not call it as a Uttama Paksha. The Uttama Paksha is for our government to support us. That is not happening, which is where we are forced to go to the court.
Right. Thanks a lot. Raviji, I know you need to, you said you need to leave at 5:15. So please feel free to, whenever you need to go.
I'll be leaving in a minute. Thank you.
Yeah. Thank you so much for
I'm sorry about that, because I have a darshan 6 o'clock, so
I know.
I cannot continue.
Yeah.
Thank you.
Thank you so much. Sundar, can you move to the next slide? Okay. I think revenue collection, was already covered during the presentation. But the second one, right, can the revenue of all temples in Tamil Nadu or whatever state, even Karnataka, follow collectivization method for distribution of the revenue? So Kiranji, you have any thoughts on this?
Whatever the government collects, and it is as a percent of the net income of the temple, 10% and 5%, it goes into a common fund and it gets redistributed from there. Unfortunately, it is the redistribution that is a problem. Not only that, but there is also milking that goes on, as the government directs some of these temples to donate 1 crore for some flood relief, for some drought relief. So there is a unlawful, I won't call it unlawful per se, but there is because it gets camouflaged as a voluntary donation being made by the temple authorities, the local devotees of the temple. And when you camouflage it in that manner, although there is a diktat from government that has gone out seeking those funds, it becomes part of charity. Only thing is, government is demanding a money, certain amount to be paid towards drought relief, which is illegal. But that's going on. The law on this subject is very clear. There is a defined percentage that goes into the common pool, and from there it gets redistributed. Essentially, that money is used for maintaining impoverished temples, but that doesn't happen. Reality is something different, and that's the reason why you see dilapidation, you see poor maintenance, you see the temple precincts being very dirty. You have all that going on. It's about misappropriation. It's about embezzlement. All of this that is taking resources of temples away, chipping away at temple resources. That's the reason. It's a large problem, no doubt. But honestly, we have to. Hindus should work on it as one and fight for autonomy. That's the only way. And central government presumably pressure can be exercised on them, and they can come out with an overarching legislation on this someday, hopefully. Till then, we've got to go piecemeal basis.
Thank you. The next one is about how well the temple lands and assets, how good the legal documentation as it exists today is, right? Or are there any gaps that need to be addressed to fortify them, from encroachment and fraudulent claims by work for any other party?
The temple, the general lands revenue records are fairly well maintained. Unfortunately, some of those records get destroyed. There are all sorts of fraudulent activities that get committed by guess who? Oftentimes it's the local Hindus. We are a divided community, so the local villagers may think it is easy. That land belongs to me. After all, it belongs to the temple. So they end up encroaching temple lands, and then it becomes that much more difficult to get them vacated. It's a huge problem, and it can only be addressed locally, at the local level. So long as there are local activists who are seized with the matter and who are working on it, that's the only solution, because it would be a local land grabbing issue. Legislation's there to support it. It's one of information, collating the information, and then fighting it out in a court of law.
Okay.
Just one related question. There was that came in the chat, right? So, is there any website where one can go and check this document? Is it digitized and available for public access, or it is not?
Yes, in Karnataka, it is available online. The portal is called Bhumi. But Bhumi is one of the portals. You have to start with the village map and then piece it together. Then there are hissas that get carved out of survey numbers. So you got to look at the survey records. Generally, land records, and I'm only talking agricultural lands, primarily, because the temple, if it is in a village, most of the lands that belong to the deity, that are owned by the deity, are agricultural lands. I can easily list about 150 to 200 different records. They would have been mutated. So the original grant or the original endowment would be presumably, I mean, if it is available, if it is there, well and good. The problem in Karnataka was the legislation that we have today is it's a consolidated legislation. Karnataka had about 6 or 7 endowments legislation post-independence. After reorganization of states, we had some parts of Karnataka being, that were under the Tamil Nadu HRCE. Parts were under Hyderabad legislation. Part of it was under, some districts were under the Bombay Ports Trust. Kodagu had a different enactment. Mysore, the erstwhile princely state of Mysore, had its own legislation. That legislation was religion agnostic. That got, when consolidation, there was a Supreme Court judgment, the Admar Mutt judgment of 1980. Post that judgment, the Karnataka government unified the legislation, and that was Hindu temple specific. That's the unfortunate part. And still there are, it has been challenged, constitutionality of the legislation has been challenged in the Supreme Court, but that actually derogates Hindu rights, because one of the main contentions is Mutt controlled temples should also be brought under the ambit of the legislation. So anyway, so there you are.
Sure, thank you. I think the next category is a set of very specific scenarios. So I think in the interest of time, we'll skip this today because I know Raviji has already responded offline to these questions. So we'll publish the responses in the group, right? Okay, so we can go on to the next category. Yeah, I think there's a question about how to restore the economic ecosystem, because temples, attract pilgrims and then aid the livelihood of locals. So how can we improve this experience and communicate? I think Raviji spoke about communities that historically lived around the temples and providing various services to the temple. They've also migrated. So the demography and the culture also have changed. So are there any organizations or any initiatives on this, on this?
I know in Karnataka, I know of several people who have formed trusts and societies to take care of their family deities and Kula Devatas and what have you, Grama Devatas, etc. But the key to this is essentially religious activity involving the deity, the upacharas that you perform, the nitya pujas that you perform, the upkeep of the temple, the maintenance of the temple. All of this has a bearing. And that not only gets the local community, but it also gets the, if let's say it's an annual fair, it gets people from the entire taluka or maybe even the district and even the state congregating. And that contributes to the economy, the micro economy around the temple itself, the village and the local economy. And that is something, if there are people who are activists or Hindus who feel strongly about their Kula Devata or temples, their family deities, I think they should start. That would be a good beginning by contributing to these upacharas, ensuring that the archaka there is paid an extra, gets an extra income, and he carries out nitya puja. There is no dearth of, the flowers and the ingredients, the different materials that are required for various pujas. That's a good beginning itself. And how you go about carrying out these activities is something that can be talked about. I already mentioned a trust. And if you want to broad base it, the local forming a society would be the right way to go about it. But make sure that the society does not end up with huge amounts of money being endowed to it.
Okay. And I think that also answers the next question, right? So unless you have something specific, okay. Okay, go to the, okay, I think there's a last set. I think how can the general public get to know more details about a temple? I think RTI was mentioned, but then what particular aspects to look for in terms of, the religious rights of Hindus?
Simple things like when you visit a temple, if you see there is something that has not been done, let's say, something that has fallen down, or the dwara is the hinges, it has come off the hinges, taking it up and as a challenge and filing RTI applications, asking for the local administration to give details of what action they have taken, asking for audit reports, going through the audit objections that are there. That's a good beginning. And then, but the problem is, instead of rushing to the court, making sure that the local remedies that are available and the avenues that are there are exhausted is what I would recommend. Because whether we like it or not, we all know that the courts are overwhelmed. And for a simple thing like something not being maintained well, you don't want litigation to go on for 5 years, 6 years, 7 years, 8 years. So that's the problem. And then they will come back saying, it's all been taken care of. It's become infructuous. You fought it out in a court of law for 5 years only to be told that government has taken care of it. Instead, a better approach would be to either tell government, because if you tell government that you're willing to pay for a certain repair, so long as you don't put money into government coffers, getting their permission itself is a good beginning. The C category temples, they will never say no. If you say we want to carry out, let's say, Brahmotsavam, they will agree to it, provided their representative gets to know what you're doing, and their representative is in control, and you don't generate or do any fundraising in the name of the deity.
Okay. I think the second one also was sort of covered by your answer, right?
Right.
I didn't feel. Okay, I think the last question is a good concluding question, because I think awareness is a big problem amongst the Hindus, right? Awareness and unity. So maybe you can take this opportunity to give a concluding statement, on this.
I sometimes think either we are dumber than dodos, or we belong to the, in terms of lineage, we belong to Kumbhakarna. We are deep in slumber. Each one of us needs to do our bit. I gave the ratio 2,500 Hindus per temple under government control. You need 5, if not 25. And don't even look at the A category temples. It is next to impossible getting, let's say, Sabrimala, getting control over Sabrimala temple, getting it out of Devaswam, next to impossible. We just concentrate on the C category temples and get government to relinquish it, because that's an extra burden, overhead on the government, on the state exchequer. Government would love to get rid of them. And only challenge is, how do we minimize the role of government bureaucrats in the committee of management that gets formed is the real challenge. So long as there is an overarching solution, or even an amendment to local legislations, state legislations, that we can see to it, we can ensure they take care of it, we should be okay. That's a good beginning.
Thank you so much, Kiranji. I think it was a very session that not just awakens us to the extent of the problem, but also inspires us to think about ways in which we can contribute. Thank you. Heartfelt thanks to Raviji as well as Kiranji for sparing their valuable time and sharing their perspectives. Thank you very much to everyone who registered and participated in this session. As I said earlier, this is not a one-off event. We want to make this, it's just the beginning of something concrete and long-term that we want to carry forward. So I request everybody to not leave the WhatsApp group after this. Let's stay in touch and come up with ways of doing something for our temples. I think that's something that I think it's high time, but better late than never. With that, Jai Shri Ram. Thank you, everybody. And we conclude this.
Jai Shri Ram to all of
Thank
you.
you very much.
Jai
Jai
Shri
Shri
Ram.
Ram and Vande Mataram.
Vande Mataram.
Thank you. Thank you. Thank you.